sooner than I was expecting. So hopefully you guys can see me. I'm trying to get this camera mounted properly here so I look squared away. All right, so coming at you live from Summerlin, Nevada today. Just got my squared away haircut. I'm meeting some of my buddies from the Marine Corps over at the Leathernecks Bar and Museum later today. At least that's the plan. And I'm headed over to the gym to get a little workout in, do a little cardio, pump some weights, trying to stay squared away and all that good stuff. So how you guys doing today? I am attorney Michael Eline. I am an attorney licensed in California and Texas. Been practicing law for about 20 years. And today I'm going to go back into the saga of Lane Myers. And this is a really interesting case. It's an Arizona case, so everything that I do, as in all of my programs about Lane, at least until I get my Arizona law license, is going to be purely for entertainment purposes and how I would handle the case as if it was in California or Texas, which is where I am licensed to practice law. Other than that, it will be based on general legal principles or U.S. Supreme Court federal type precedent or precedent, if you prefer. So hopefully you guys who have been following me understand what I've been trying to do, and also understand that I've been suffering from pretty bad sciatica. So going to the gym, stuff like that, is I haven't been able to lift as heavy as I normally do, and I'm basically just going to the gym to try to get my stretching done and a little bit of light cardio and things like that. So, because I know some people are saying, hey, how come you haven't applied to the Arizona bar yet? Because I am eligible to be waived in to the Arizona bar. I've got over 20 years in practice. I mean, assuming arguendo, I meet all the background and all that, which I should. But my background is, yes, I started in appellate law, appellate practice and procedure. I became a lawyer on the California State Bar Law Office Study Program, which is a program that allows someone that doesn't have an undergrad or a law degree to study under a judge or judges and lawyers for 4 years, as long as you pass the first year law students exam, which consists of contracts, torts, and criminal law. And so I passed the first year law students exam and stayed on the program, became a lawyer with no law degree or undergrad, was actually waived into a law school during that time period. I was able to have all the first year courses waived, so I didn't have to. Yeah, because typically I would have like at least a couple hundred people in here. So that's no good. So Gloria, can you see me? Can you hear me? Okay. So Liberty says you can hear me. Okay, cool. All right on, Gloria. Yeah, I know there's a little bit of a delay. So look, I'm at the gym now, so I'm going to try to get a workout in. But in a nutshell, yes, you can sue a judge, you can sue a prosecutor, and you can also go after them criminally, like the feds could go after them if they did something that went far beyond their oath to uphold the law, and they maliciously and criminally went after somebody like Lane. And you could also go after a private person who brought false charges and used the power of the state to try to make an arrest against Lane. And that would be under what we call the state actor theory, where a person acts as an instrumentality of the government, and in that case, they basically become subject to a civil rights lawsuit. And so that's okay. So how long has it been that I? So just now you're able to see me, or I mean that's terrible. So did anything that I say get recorded for the last 17 minutes, or did I just now start going live? Somebody let me know. Just now able. Okay. All right. Fair enough. Well, crap. All right. Nothing the last 17 minutes. Jesus. Okay, look, before I go work out, look, I'm going to break this down for you. All right? So I'll start off from the very beginning. Everything that I say here is purely for entertainment purposes, and it's based upon my experience as a practicing attorney in the state of California and Texas. My background, experience, knowledge, and skill is that I became a lawyer on the California State Bar Law Office Study Program, which means you don't need an undergrad or any kind of a background in the government-run school system. You can study law under judges and lawyers, and that's what I did. I externed for the California Court of Appeal. I also worked at the Los Angeles City Attorney's Office in the Criminal Prosecution Division. I have about, I think I said this, 20 years now in practice, and most of the lawyers that I studied under were personal injury attorneys. And so that is why, hey Lenny, good seeing you. I've been in refresh mode the whole time. That sucks, dude. So that is why I got into personal injury law. But I have done multiple writs and appeals, writs of habeas corpus, writs of mandate, writs of prohibition, habeas, I think I already said that, writs of coram nobis. So I have a really, really strong background in appellate law and procedure. Thanks, Lenny. I am not an Arizona attorney. I'm not professing to practice law in Arizona. I'm simply, for entertainment purposes, bringing you the knowledge that I have based upon my perceptions of the Lane Myers case, and how I would handle this case if I was in Texas or California. And I'll go back and edit this video and cut out the first 17 minutes so people who are watching the video don't get all caught up in nonsense. But just really quickly, Lane Myers, the nexus of this case started with him booing at a public meeting, at a city council meeting, as I recall, where the mayor ordered his arrest because he booed at what I perceived to be an anti-Second Amendment meeting, where the mayor was congratulating people who hate our fundamental unalienable rights to keep and bear arms. And Lane, of course, had a MAGA hat on and had his cameras with him, and he stood up at the same time everyone was cheering and booed, and he was arrested for that. And obviously that would, even though a meeting like this would be considered a limited public forum, he still has the right of free speech and the right to criticize. And if not, his fundamental unalienable rights to free speech, press, and criticizing public employees would have been abridged and violated. And in this case, they were. And so ultimately, a prosecutor brought, I guess, misdemeanor charges against him. I think his name is Walker. And he lost. And I guess he lost pretty bad. And Lane found out that there was a public university that allegedly was working hand in hand with the prosecutor's office. And so he, as an investigative journalist, determined that one of the employees that was part of this, I guess, was married to the same prosecutor who unlawfully prosecuted Lane. And so Lane, I guess, contacted her one time by telephone and then started doing videos about her. She brought some kind of a injunction against him. I think she either lost that injunction or it was dismissed. She was told by the judge that she could not bring it again, and she brought it again anyways, and this judge went ahead and sealed it. I don't know exactly what happened, but that's sounds like that was what happened. And ultimately, Lane, thanks, Jeff. Ultimately, Lane was arrested, and now he's jailed for, like, I don't know, 20 or 30 felonies. It's pretty crazy what they're doing to him. And so several of my members asked me, could Lane, if he wins this, and he probably won't win it until he goes up on appeal based upon how bad they want to get him. But what could Lane do? Could Lane sue? And so, and again, I'll couch this as if I was in California. Well, Lane could sue for false imprisonment. He could sue the mayor for false imprisonment. The mayor would only have qualified immunity. So that just means there's a rebuttable presumption that the mayor acted in the course and scope of the mayor's duties. And as such, the mayor could be sued for falsely imprisoning Lane. And I actually found an organization. There's a woman named Massey. I believe her name is Rachel Massey, and you guys can Google this. I found a nonprofit that represented her, and I'm in the process of contacting them to see if maybe they can help Lane. But ultimately, yes, you could pierce that shield of qualified immunity and you could go after the mayor. And potentially the mayor could even have criminal charges, maybe even a RICO claim brought against her by the federal government. Possibly. It depends on, look, everything in this world, unfortunately, depends on how much the press picks things up. Like the black dude who had the cop that put his weight on his neck. He was high on drugs and he was passing fake $20 counterfeit bills at a liquor store. People were terrified of him. He had felonies against him for pointing a gun at a pregnant woman's stomach, and really just a bad guy. Now they have monuments to him all over the country. Well, in Lane's case, he didn't do anything like that. So it seems to me like this would be a case where popular opinion and the press might get involved, because Lane's just out there trying to exercise his fundamental First Amendment rights. Give me a bunch of ones if you agree. So that's my take on it, is unless you guys get a lot of publicity, do recall elections, and bring a lot of attention to this, Lane's case is going to be very difficult. So let's get into it. So in Arizona, what I found is that false imprisonment is unlawful imprisonment, and I found that to be under A.R.S. section 13-1303. It involves knowingly restraining someone without legal authority, and if you wanted to sue for false imprisonment, you'd have to show that you were intentionally detained or confined without consent, that the detention lacked lawful justification, there was no valid warrant or probable cause, and that you suffered harm. Or physical or psychological distress, that could be considered harm, okay? And obviously, you could also sue for due process violations under the 14th Amendment for deprivation of life, liberty, or property by government actors, such as denial of fair procedures, lack of notice and opportunity to be heard, bias or misconduct by a judge or a prosecutor, a judge with prior significant involvement with the prosecutor in your case, for example, and failure to follow constitutional safeguards, like informing a jury of parole ineligibility in a case, for example. Very difficult to do. So the defendants in their roles are what are most important. So a mayor, obviously, you could go after them. There was a case in Surprise, Arizona that I just recently mentioned. I believe the lady's name was Massey, Rachel Massey or Rebecca Massey. That's something you'd want to look at. Now, a prosecutor, again, I said this earlier, but it sounds like you guys missed it. A prosecutor typically has absolute immunity. So if they did things in the course and scope of their duty as a prosecutor, like filing charges and presenting evidence, they are immune, and there's not a whole lot you can do. But they could be liable if they knowingly falsified evidence or records or engaged in misconduct during an investigation or withheld exculpatory evidence because they had an animus against the accused and they wanted to get a conviction. So that's a problem. And then a judge, again, absolute immunity. Anything they do for actions taken in their judicial capacity, even if it's erroneous or biased, unless you can show they acted without jurisdiction, it's very, very difficult to sue a judge. But you can. It is possible. And then, of course, municipalities and governmental entities can be sued for unconstitutional policy violations or failure to train officials, like negligent hiring as well, negligent training. So negligent retention even could be a potential basis. But again, in those cases, you also want to look at the 6-month statutes. Government, in order to sue them, typically you'll only have 6 months to file a government claim, and then you have to wait for your letter to sue, or 6 months, whichever is sooner or later, I guess. Well, 6 months or a letter to sue. And if you don't get a letter to sue after 6 months, that would give you the legal authority to bring a lawsuit. So typically they'll send you a letter saying, we don't find any merit to your claim, go F yourself. And that's a letter to sue. That gives you the authority now to bring a lawsuit. So typically you'd want to be bringing these claims under Title 42, Section 1983, under federal civil rights law. And you'd want to go after the prosecutor for malicious prosecution, which is very difficult to do. But if the prosecutor knowingly pursued baseless charges, you could claim this. It would require proof of lack of probable cause, as well as malice and termination of the case in your favor. So you'd have to win that case as well, typically. And that could also include winning the case on appeal, okay? Because none of us really expect him to win the case at the local level at this point, who are lawyers anyways. That statute, in my opinion, is so broad and so ambiguous that everybody's guilty of harassment. And that's why the Arizona legislature is reviewing it. I think they know that. So overcoming absolute immunity is very difficult. Typically, prosecutors and judges will be protected by absolute immunity for things that they've done in their official roles, like deciding a charge. But if they fabricate evidence, they may not be, or if they withhold exculpatory evidence, they may not be. All right, give me a bunch of ones if you understand so far. Now, a judge's ruling in court are immune, but non-judicial actions like ordering an arrest outside of their authority may not be. And that's why I believe that Lane does have the ability to go after Judge Ball. I think that what Judge Ball did, if this was in California or Texas, definitely has opened him up to a Title 42, Section 1983 claim, without a question about it. Now, qualified immunity, again, police, mayors, they can claim that, but again, it's a rebuttable presumption of immunity, so it's not absolute. And all you have to really do is to overcome it is to show that their official conduct was objectively unreasonable, all right, to an objective, reasonable person. Hopefully you guys get that. Municipal liability, like bringing a Monell claim, like failure to train. So Monell under Title 42, Section 1983, pattern and practice of violating someone's rights. Now, for Lane to build the case, he'd have to document the detention, arrest records, court documents, jail records, to show that everything lacked probable cause. He'd have to show evidence of misconduct through witness statements, video footage, or official communications through the mayor, the prosecutor, or the judge. If it turns out that this city prosecutor was working in tandem with the county prosecutor to get a false conviction because, again, he's married to one of the victims and he's leading the charge, which obviously has a lot of ethical issues as far as I'm concerned, that's a problem. And so that's why they're pushing so hard to get this conviction by an admission. They want him to admit that he did all these things because then it absolves them from being sued or even criminally investigated by the feds. So that's why I'm kind of proud of Lane for not giving up. Now, proof of harm. So how would he show that he was harmed? Well, medical records, financial losses, psychological evaluations, documenting the imprisonment. I mean, we know that according to him, he was attacked physically by at least one correctional officer. That's a problem. And yes, you definitely can get evidence through FOIA, but FOIA is federal, guys. FOIA is the Freedom of Information Act. It's a federal act. You'd want to find the equivalent of the state law, of the state rule. That's how you would do that. And you would follow those procedures and you would get those records. Typically what they'll do is to say, oh, there's an open investigation. We can't give you the information. Do anything they can to prevent you from getting that information. Unfortunately, that's been my experience. But words mean things. So be careful when you say FOIA because it makes you look like you don't know what you're talking about when you deal with these government employees and they just laugh under bated breath. So make sure you know the equivalent of the state version of FOIA when you're doing this, guys. I know what you mean by FOIA, and I don't think that you're dumb. I just think that most people don't know that there is a state functional equivalent of the federal rule of getting public records, a Public Records Act in your state. That's all. It's no big deal. You just have to know the difference because when you're trying to get information, if you say, I want to do a FOIA request, they'll be like, what the hell is that? We're not a federal agency. All right. So the next thing you want to do after that, if you can prove these due process violations through court transcripts or other evidence showing procedural unfairness or lack of a fair hearing, then you can file your lawsuit. And so typically, if you want to file a claim against Arizona public officials, you'd want to file that claim within 180 days. And the law that I found on that is A.R.S. section 12-821.01. And again, I would talk to an Arizona attorney. Don't take anything I'm saying as legal advice. I'm just regurgitating what I found because I have an Arizona criminal practice and procedure guidelines book that I'm looking at because I'm getting ready to try and get admitted into the Arizona bar. So I want to make sure I understand how things work in case I do get called as pro hoc counsel to help Lane. And I'm not saying that's going to happen. I can't promise you guys anything. I'm just telling you that if my health holds up, Because right now, if I sit on an airplane, even for like 20 minutes, like sitting in this car right now, my whole leg is on fire. But I'm just trying to bring this information to you guys, all right? So just bear with me. So you'd want to choose the court to file in. Would it be federal court under Section 1983, or would it be in state court in Arizona for like a false imprisonment claim? I mean, my gut tells me probably federal. I just don't, I think the entire judiciary, based upon Mr. Walker's petition to deprive people from being able to audio record in court, and then seeing that so many court commissioners and even the Arizona bar is on board to prevent people like us from being able to audio record in court, I just feel that shows an overwhelming bias in the entire justice system in Arizona against pro se litigants like Lane. That's how I would do it. And I am going to go to a chiropractor again, and I am doing belly stretches, brother. But thanks, Richard. I appreciate that. So you'd want to either file in federal or state. Again, if you're going to file in Arizona state court, you've got to abide by that 180-day rule, like what we would do in California. And typically, there might be a tolling of the statute. So keep that in mind. So the 180 days, typically, at least in California or Texas, doesn't start ticking until the actual damage has been provable. So once he's found not guilty or he gets the case reversed on appeal, that's when the 180 days would start ticking, at least with respect to the current charges. Now, the charges that were acquitted against him, against the mayor, that 180-day clock would have started ticking from the day that he was acquitted. Okay, just so you understand the difference. It doesn't mean that he couldn't bring a federal civil rights case for that. I'm not sure what the statute is in Arizona. It's either a year or 2 years from the date of the damage. And the date of the damage is the date that you were acquitted, right? In a civil rights case like this. So what you would do is you would want to serve process. So you want to serve a copy of your complaint on the parties that you're suing. And typically you'd want to use a process server. I found a rule called Arizona Rule of Civil Procedure Rule 4 that talks about serving the summons and complaint. So it's the complaint as well as a summons to appear in court. Typically in California, I would pay like $600, I believe, to file a lawsuit. And then I think that the defendants would file an answer. I think that's about $600 as well. And then federal has a similar procedure. Now, unless you can prove that you are in forma pauperis, that's the Latin term for you're too poor, you're too broke to be able to afford it. And then you're found by filling out a financial form that you can't afford it. And then you would be able to have those fees waived, okay? So you would seek a fee waiver based upon being poor, all right? All right, so the immunity barriers would be the biggest issue that Lane would have to deal with. He'd have to also deal with the statute of limitations, including the false imprisonment statute. In California, we have a 2-year statute of limitations for false imprisonment. So just so you know. And then the burden of proof, again, you just have to show the detention was unlawful and there were due process violations, and then there's going to be cost versus recovery. So that's another issue. A lot of you guys are like, why don't you sue everybody? Like, why didn't you sue for BZ Watchdog? And I'm thinking to myself, well, obviously these guys aren't lawyers, because the costs of me filing a lawsuit, paying all these fees, because if you can afford a lawyer, you're not going to get a fee waiver, first of all right? So the cost of me paying all this stuff out of pocket and advancing fees typically is going to be less than the provable damages. I've had many cases that I brought on behalf of people where I've won the case and the jury just didn't like my client, thought he was a dick or whatever, and awarded him $1. And I'm stuck basically with all the fees, because how am I going to ask my client to pay back all those fees when they're broke already? So as a lawyer, I always look at cost versus recovery. So always remember that, guys. Sometimes the potential damages are going to be less than what you could recover. So always make sure you consider that when you're filing a claim. Now, if you're somebody who just wants justice and you're not looking for money, that's something you may want to consider bringing pro per or pro se, or bringing in small claims court, okay? Give me a bunch of ones if you guys understand so far. I'm just looking to see if you have any questions. And good seeing you, Gloria, by the way. Thank you for joining me today. Now, the next steps. Well, you'd want to obviously reach out to an attorney if you don't want to represent yourself. You'd want to make sure to file that complaint, either with the Civil Rights Division of or report it to the U.S. Department of Justice's Civil Rights Division if you think you've got a criminal case. So that's pretty much it. You want to always consider your alternative remedies. If a lawsuit isn't viable, explore again the government claim and explore recall elections, guys. I keep telling you this. Explore recall elections. Explore getting the press involved. Explore using the leverage that you have on your YouTube channels to be able to get enough public attention. The same way that felon who ended up dying of a drug overdose, where BLM caused like $3 trillion worth of damage at the behest of the news media like CNN and PMSNBC and all those guys. There's no reason why you can't do it peacefully by getting the press and getting public attention, and then leveraging your YouTube channels. Guys like I got like almost 60,000 subscribers now. I think This Is a Public Service has more. And then Reluctant Prophet has like 50 or 60,000. Chili De Castro has almost 700,000. John Felix, I think he's got 300,000 or 400,000 or more. And we just get all these guys, get every First Amendment auditor, everybody who believes in government accountability, to say, hey, we're willing to help Lane. And if your firm or your nonprofit agrees to help, we'll help you advertise your services so you can get more cases. And that's what I would do. Yeah, mostly peaceful, right, Rich Spillman? Mostly peaceful. SIG beats 9mm. 357 SIG beats 9mm. I love that name. That's cool. I like 357s too. I actually have an S&W 500 as well with bear loads, and almost broke my wrist last time I shot that thing. It's like a cannon, man. All right, and I've got a 357, and I've got a Ruger 44 Magnum. Bunch of cool stuff. Right now, my carry in my car is a HK VP9 with a custom trigger with Trigicon sights, and it's a striker. I really like it a lot. I typically will carry one in the hole when I don't have my family around, and then I'll do Israeli draw when I don't have the kids around, just for safety purposes. You never want to have something in the chamber when you got your wife or kids around. You never know when they might pull that sucker out and pop one off. So just remember that, guys. You need to know where you are at all times and always look cool while you're doing it. So lawsuits against public officials are challenging due to immunity doctrines and have a high evidentiary burden. So keep that in mind. Thanks, Justin. I've got a bunch of them. So the one on my show I had on last night in the background, that is a Glock 21. I typically, for my house gun, always like to have a 45. That's the one with, and you want to have hollows. You want to make sure you've got a really soft round so it's not going through your walls into the neighbor's house. So if you do get home invaded or something, and you always want to go for headshots because you never know when they're going to be wearing body armor. So headshots or leg shots, believe it or not, shooting for the groin and the legs is probably going to drop someone faster than a center mass shot. That's a fact, and you'll bleed out much faster. Leg shots are more deadly than body shots, by the way, guys. A lot of people don't know that. I like 10 mils too, Grateful Debs. To me, it's a little bit too hot of a round. I like to have a slow round that's going to have a lot of knockdown power. My experience with friends in MARSOC and a couple of my Navy SEAL buddies, based on what they've told me, is that a real hot round like that goes right through you and doesn't have that knockdown power. Well, unless of course you're carrying a nice hollow point, right? That's gonna mushroom. But yeah, I love 10 mils, dude. I love them all. 40s, 10s, you name it. I've got pretty much everything you can imagine. But my everyday carry for car, for defense of the car, is gonna be a 45. And then for my concealed carry, it's either going to be a 380 auto, or in this case today, it's a VP9. It's concealable enough. So it's concealable enough, if you're wearing one of those little purses, no problem. So that's kind of the way I would go with that. But I'm going off topic as usual. You get me talking about firearms and I can't stop. 22 Magnums are pretty cool too, and especially if you've got hollows. And look, I just like knockdown power, so the 45 is my go-to for close quarter battle. But I got my AR-15 as well, and that's my go-to for all purposes. So you always want to go to your rifle first. Your pistol is usually just a backup. And obviously I can't be carrying around an AR out in public, so naturally I got to have something. So it's going to be a handgun. All right. But anyways, again, lawsuits against public officials are always challenging due to the immunity doctrines, but an attorney will be able to assess these cases better for you, the nature of the detention and the nature of the official's actions in the context of a due process violation, and then you'd be able to tailor it from there. But hold on, I'll let you guys, what do you guys think of my shirt? Amendment 2. Like that? Amendment 2. So I'm wearing my Second Amendment shirt today. My Second Amendment jersey. All right, so to recap, yes, you can sue government employees, but it's very difficult. Prosecutors and judges are going to have absolute immunity, and you're going to have to show that they acted far beyond the scope of their duties to the point where it was basically malicious and illegal and unlawful. Going after a mayor or a cop is going to be a little easier because all you have to do is rebut the presumption of qualified immunity by showing that they acted beyond the course and scope of their official obligations and duties. So that's the way you would do that. Now, I do intend on, thanks Grateful Dabs, I do intend on interviewing Lane either tomorrow or the next day. And if you guys have any questions that you want me to ask them, please put them not here in the chat, but go to where it says comments on this video, go to the comments section and type them in. So I can create a list of questions and I'll give them your name and I'll let them know you're thinking about them. And I'll ask those questions for them and try to get answers for you. I'll try and audio record it if I can, as long as I'm not going awry. I don't want to get Lane in trouble, but if there's a way that I can audio record it and bring a show for you after it's over, I don't think it can be live. We don't want to cause any troubles for Lane. I'll do that. And, we'll go from there. So again, if you have questions for him, please put them in the comment section of the video. And then when I get back to the office, I'll edit out the first 17 minutes of this video. Please forgive me. I don't know what's going on. I thought that we were recording for the first 17 minutes and we weren't. So I will make sure that we do that. And yes, they would be requestable, Yellow Cat. Anything that was done within the course and scope of their official duties. Of course, their out is that there's an investigation in process and that they don't have to turn it over. So just keep that in mind. But hopefully I was able to teach you some stuff today. And let me see here. Sir Richard says, cops play cards on the street. They draw qualified immunity. I throw down my cards with diplomatic immunity. All right, I like that. Richard, I think you're in Australia, right? So we got guys from all over the country following this. Again, I do want to ask you guys to consider forming an alliance where you start trying to do a recall election against the players in this case that are going after Lane if you think that they're in the wrong. I believe that is one of the only ways you'll get the necessary news media attention. And then the second thing that I would ask that you do is any of you who really want to make change and change the system, consider getting involved in public office. Run for school board, run for sheriff, run for city council. Use your YouTube channel and all of us on YouTube to help promote you in your run. If you really want to change the system, I think the only way you're really going to change it is from within. I've met plenty of whistleblower cops. I've met plenty of whistleblower prosecutors in my life and my practice of over 20 years. And I am of the conviction that not everyone who's on the police force is evil and bad. I do believe that a lot of people get into this job, especially military guys like me, because they think that they're upholding and defending the Constitution. But the problem is when you've got like 10 or 15 in, right? This is the problem, guys. When you got like 10 or 15 in and you're looking at losing your pension and you're losing your retirement, unless you go along with it, that's the problem. And so that's another thing that we need to focus on is coming up with some statutes and codes federally as well as at the state level that protect whistleblowers to where they get their full retirements when they get forced out or constructively terminated. Give me a bunch of ones if you agree that will be a great way. Because a lot of people, when they've got a wife and kids and they've got all kinds of injuries, right? They'll just turn the other way and do the walk of shame rather than lose all of that. And you can be an armchair general and say that they're wrong, and I agree that that is wrong as well. But I think that we should also make it easier for them to not turn their head by having laws in place that protect them. That's all I'm trying to say. And again, I do appreciate all of the likes and subscribes. I appreciate the super chats and the memberships. If you guys really want to support my channel, go to the description on my profile, push it and open it, and consider buying a copy of my book, My Journey to Becoming a Practicing Lawyer with No Law Degree or Undergrad. It's a digital ebook that I'll send you. You go to PayPal, you pay $19.99. I take the email that you include, and then I send you an electronic copy of my ebook. Even if you're not interested in becoming a lawyer, it's a really motivational book. Talks about how anybody who is motivated and wants to make change in this world can do it. It's my story, and I also cover other cities, other states that offer similar programs to where you too could become a lawyer with no law degree or undergrad and try to make positive change for this world. Not everybody has hundreds of thousands of dollars to go to law school or to go and get an undergrad before they can go to law school. So I show you alternative methods to be able to do that and make positive change in this world. So with that being said, guys, I think I'm going to go ahead and hit to the gym. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. Hey, boa tarde. Let me see here. Jose Antonio Rossetto says hi from Brazil. So boa. I'm a big time BJJ guy, so I learned all my Brazilian on the mats. And don't get into too much porra when you're on the mats, man. Don't hurt anybody. Okay, Jose? All right, guys. So Paul Smith, you're a female. All right, man. All right, Paul. Well, with a name like Paul, you must be a single female from San Francisco. So, but no, I'm not. I'm happily married, and I've got 2 kids. My son is a judoka, and his first judo tournament is going to be this weekend. So I'm trying to get him ready as well. And then Quad Pro says, I didn't learn anything, watched a lot of commercials. I don't know what that means. But if you go back and rewind the video, you should be able to. And we should do a live over Streamlabs and get all the auditors and everybody. We should do that. A little bit of Portuguese, just Brazilian Jiu-Jitsu style Portuguese. Hip tossing, folks. That's right. Every day and twice on Sunday. That's probably another reason why my back's not doing too hot. All right, guys. Anyways, again, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. Semper Fi, do or die. And again, I'm going to edit out the first 17 minutes of the video as soon as I get back to the office. Sorry about that. I don't know why YouTube didn't have me with audio and video, but at least we were able to resurrect it, right, guys? We resurrected it. Love you, Dad. Take care, brother. See you later. I love to game. Take care, guys. Bye.